Bismillahir Rahmanir Rahim. Alhamdulillah. Wassalatu wassalamu ala Sayyidina Rasulillah wa ala alihi wa sahbihi wa man wala. Welcome back, everyone, to lecture 11. Continuing in our reading in this section on courts and testimony. I'm going to backtrack just a little bit to talk about some of the things I feel maybe in the last lecture I rushed through, which is the judge not accepting the testimony of an enemy against an enemy, a son against a father, father against a son, and then we'll enter. And then the thing about a judge's written ruling that is sent to another judge is not accepted until two witnesses. So this is basically about jurisdiction. The thing about the testimony part, not enemy against enemy, I think we kind of did that. Maybe I don't have to start there, but I definitely want to recover or redo the section about jurisdiction, because that's something that happens frequently in the pre-modern world and in the modern world. People are all over the place and have disputes all over the place. As a matter of fact, in contracts, it will usually say what court system is the authoritative court system that would arbitrate if there's a conflict. And then we're going to talk and then move into another section, which is a dividing property. So a lot of the court cases that we're talking about, the background or the bias of the Sharia is that this is in the issue of when there's money or land that's involved, that there's a dispute about material things. Of course, there can be things about murder and other type of crimes, but more typically it's about money. And therefore, we have a section on dividing property. So if the judge rules in a certain way. So dividing property, by the way, is not just for disputes, but also for inheritance. So the inheritance and then the bequests, the wasiyah that comes before the distribution of the inheritance, that's also a major part of the courts. So when somebody dies and that death certificate is brought to the courts and it's certified, there has to be a way that it is the property, the estate is divided. And how do you do that? So there's a formal person who is a person that divides the property. It's a position in the court system. So we're going to learn about that position. We're going to learn about the conditions for that person, and that also that if the two parties or the parties involved are happy with another person outside of the court appointed like trustee person, then that's also permissible. So those are the main topics that we'll talk about, and as usual, we'll begin in the next clip, inshallah. Okay, so we begin the way we always begin, which is we turn to the text of Abi Shuja' radiallahu anhu, the original Arabic. قال المصنف رحمه الله ونفعنا بعلومه في الدارين آمين ولا يقبل شهادة عدو على عدوه ولا شهادة والد لولده ولا ولد لوالده ولا يقبل كتاب قاض إلى قاض آخر في الأحكام إلا بعد شهادة الشاهدين يشهدان بما فيه. فصل في القسمة. ويفتقر القاسم إلى 7 شرائط: الإسلام والبلوغ والعقل والحرية والذكورية والعدالة والحساب، فإن تراضى الشريكان بمن يقسم بينهما لم يفتقر إلى ذلك. Okay, so Qadi Abu Shuja' radiallahu anhu, he says, may Allah Ta'ala have mercy on him and may we benefit from his knowledge in this world and in the next. He does not accept an enemy the judge does not accept an enemy testifying against his enemy, a son testifying for his father, or a father for his son. A judge's written ruling that is sent to another judge is not accepted until 2 witnesses testify concerning its contents. Section on dividing property. Someone who divides property for the court must meet 7 conditions. The person must be a Muslim, mature, of sound mind, free, a male, upright, and trained in arithmetic. If 2 or more parties agree that a particular person performs the division for them, the above conditions are not required. All right, let's go into the adillah very briefly to see what gems we have from the Quran and Sunnah. We did the written and stuff, we did that in the last class, so I'm going to just start with the division. So Allah Ta'ala says in Surah An-Nisa, verse 8, وَإِذَا حَضَرَ الْقِسْمَةَ أُولِي الْقُرْبَى وَالْيَتَامَى وَالْمَسَاكِينُ فَارْزُقُوهُمْ مِنْهُ وَقُولُوا لَهُمْ قَوْلًا مَعْرُوفًا. The qisma is the division of the property or the division of the estate. Let's say division of the estate. I think it's more, well, if it's not, that's only in the cases of inheritance. So division of estate and inheritance, division of property or wealth or money if there is a conflict. So إِذَا حَضَرَ الْقِسْمَةَ, so if the people come attending the distribution, in this case the estate, أُولِي الْقُرْبَى, the family, وَالْيَتَامَى, those that are orphaned, وَالْمَسَاكِينَ, those that are poor, فَارْزُقُوهُ مِنْهُ, so give them from that, divide equitably, وَقُولُوا لَهُمْ قَوْلًا مَعْرُوفًا, and be gentle in your approach. Well, in the book, in the Hashiyah, there's a couple more, so we'll leave it there. Sometimes it's not a lot, as I said. But it's a very useful book. I mean, you definitely want to download that book by Mustafa Bugha, rahimahullah, because, as I said, it's very hard to do this fiqh and to learn if you do not also at the same time learn the links to the Quran and the Sunnah. So I don't want people when they study, whether they're in the beginning or the middle or even towards the end or in the advanced levels, for any moment to think that anything that we're reading is other than an interpretation, a direct interpretation of the Quran and the Sunnah, because we are the people of Sunnah and Jama'ah, Ahl Sunnah wal Jama'ah, that's what it means. So, and as I've said multiple times, many of much of the vocabulary of fiqh and even the sentence structures that you'll find in the manuals of fiqh are taken from either directly from the Quran and Sunnah or a slightly restatement of what's in the Quran and the Sunnah. So it's something that's important. Anyway, let me go back about the testifying situation. The testifying of the enemy against the enemy, I think that's clear. But the father and the son situation is not. I think I might have misspoken or was sloppy in the previous lecture when I said testifying against. It's also testifying for. So testifying for. So I can't go and testify on behalf of my son because I'm never going to be honest in that sense. I mean, it's my son, right? Or a son for the father. There's an embedded tuhma. There's an embedded accusation of non-uprightness or non-transparency because of the sensitivity of the relationship. And then that's also the father, son, son, father, also upwards and downwards, is something that permeates other aspects of Islamic law. So if you're thinking like an usuli, you can abstract from this a qaida, some type of principle, and then this would be a fara, this would be a branch of law in which that qaida, in which that rule permeates. And that's sort of how advanced fiqh is done, is you look at all of these spurious points of law and then you lump them together from different chapters of law and then you come back and say, oh, there's a qaida here. So there is something special about the relationship between a parent and their child from the point of view of nafaqah, from the point of view of وَلَا تَقُلْ لَهُمَا أُفٍّ, not even saying uff. We talked about that in usul al-fiqh. In this case, not testifying for or against. Al-qatilu la yarith, so the person who kills their parent or the parent who kills their child, may Allah Ta'ala protect us, they do not inherit. That if a father kills their son, they're not executed for that sin, that crime, even though it's a capital crime. We've read about that, so on and so forth. So you see that these are all different points of law throughout the Islamic legal canon, but they all deal with the one same thing. Anyway, that's a tangent. Let's come back to here. What I really wanted to highlight was this thing about the written stuff. So a judge's written ruling that is sent to another judge is not accepted until two witnesses testify concerning its content. So this is an issue of jurisdiction. So if I'm a judge and I'm in the current jurisdiction, wherever I am at the current moment, and there's a dispute between two people, but one of the people lives in another jurisdiction, as usually happens when people travel. So I'm going through all of the procedures that we talked about. We heard the evidence, we verified the witnesses, by, the court verified the uprightness of the witnesses. I have enough information that I can rule on this specific thing. So I rule, for example, that Fulan that lives in another jurisdiction owes the guy that's in front of me, $1,000. Okay, that's my ruling. So now, how do you enact? This is a little bit more of how is that enforced. Well, the other guy's in another jurisdiction. So I have to now write to the other qadi, from qadi to qadi, and I have to inform that qadi of my ruling. Now that other qadi is going to receive my letter, right? Or they might receive like an email or something like that. But what makes it authoritative is that that letter has to be verified itself. Of course, we're talking about in the pre-modern world, where the letter has to be verified by two independent witnesses. Of course, in the modern world, we have some type of technologies that we can think about and we can use to leverage. There could be, like in the United States, I know in different states and counties, there is a online portal, for example. I don't know what it's called. It's called different things in different places, that any lawyer or any judge can look and see what docket has been uploaded to that. So those type of things then take the place of the witnesses in the modern world, because you can't upload anything into that system, I'm assuming, unless it's been the judge's ruling has now been officially entered into the record. So if I'm in another jurisdiction and I can access that record, then that would be a point of verification. The idea is verifying. However, in the natural understanding of Islamic law, it's going to be two people to verify that, so it will be notarized. It has to be notarized by two people that are upright. The idea behind that is that the letter could be forged, the letter could be lost, the letter will not last. And by the way, the example that I just gave of that online stuff, that stuff also doesn't last, because there can be data breaches, loss of data, power outage, the internet's down, you can't access this online portal, so you will have to rely on the testimony. And all legal systems, Islamic and non-Islamic, religious and non-religious, all are going to these are all universal legal principles. There's nothing really new here that we're stating when it comes to these last couple issues we've been talking about, the last couple of lectures. This is pretty universal stuff. It's pretty basic stuff for the legal profession. So the judge in the example that I was giving, I cast a ruling, I sent a letter. That letter has to be accompanied by two people to verify, two upright witnesses. Let me pick this up in the next lecture, in the next clip, inshallah. Okay, so at the end of this last clip, we were talking about a judge of one jurisdiction sending a letter or his ruling to another judge of another jurisdiction involving somebody that's in his jurisdiction. So he's going to have to, either he's going to have to carry out the ruling, in which case that ruling has to be accompanied by the two upright witnesses. So the example that he gives in the commentary and in the hashia is actually, very common example, which in this case I think is worth getting into a little bit. Let's say a man comes to me, or a woman for that matter, let's say somebody comes to me in my court, and I am in jurisdiction A, and he says, I was doing business with Fulan, who lives in a neighboring area, town, even country or something like that, using modern language, and we had the business didn't go as planned, as a business usually never goes as planned. Even the successful businesses, the success is never as planned. It's another tangent I don't want to get into right now. And the upshot is the guy owes me $10,000. Okay, well, where's your dalil? Where's your proof? Oh, here it is. Here is this. Here is that. Here's the guy's statement. So it's pretty clear from the evidence that's presented that there's not, there's nothing for me. There's no need to hear from the other person, because the other person, the documents that have been presented to me are signed agreements of the other person. So remember, we said if the plaintiff begins, which the plaintiff has to begin, and then the defendant confirms some part or all of what the plaintiff said, those parts that are agreed, there is no need for evidence because it's khalas, it's agreed. So if I see a signed contract and if it's notarized and it's stamped and it's been the registration number for it being submitted to the local municipal or authorities is there, then as a judge, okay, well that's pretty clear. So I'd be like, okay, you have to give him money. Now, how is this guy in front of me or this girl or this woman in front of me, how are they going to get their money? Well, I have to write to the other judge in the other jurisdiction, and that's the case in which this part of the fiqh becomes active. Now, if the person in front of me, just kind of riffing off of this example, if the person in front of me, in the example that I just gave you, there's a shared bank account or something like that, and there was something bad that happened, so in the business, so the bank froze the account, so none of them can get, and they're both sort of, they both have access to that account. I'm just making this up on the fly. They both have access to that account, and I, as the judge, have determined, okay, actually you do need to take $10,000 of that account is yours. I can instruct the bank here in my jurisdiction to release that amount of money and give it to him. But the issue of the letter going and having two witnesses to verify that letter is in the case which usually happens when the money is not present. Okay, so if the money is not present and it's with that other person, he like absconded, he like took the money and the stuff, then that's where I'm going to write a letter to the other judge, and in that case that has to be verified lest there be sort of like a problem or somebody would accuse somebody of lying or impropriety. Okay, then he has a little section about the writing, the ruling of the judge. Now this is a very, very, it's not even like Wikipedia level entry. This is like a tweet. Okay, this is very, very simple stuff. And there are many, many books in our Islamic library that speak about these things in spades, and we also have records, as I've mentioned before, manuscripts and records of many, many Islamic jurisdictions over almost 1,000 years of recorded Islamic history, Islamic legal history. So he says the judge will say, Bismillah ar-Rahman ar-Rahim, in the name of Allah, the most merciful and compassionate. Hadara indana, came present before me. Afani Allahu wa iyak, may Allah Ta'ala preserve me and preserve you. Kind of a dua for safety in this world and the next. Fulan, so and so. وإدعى على فلان الغائب المقيم في بلدك بشيء الفلاني. So present with me was this person, and I named this person, probably will give an ID number, who made a claim against such and such person, his name and ID number, who lives in your jurisdiction, O judge, with the following issues, and then you enumerate the issues. وأقام عليه شاهدين, and testifying and bearing witness on this issue were two witnesses. وهما فلان وفلان وقد عدل عندي, and the witnesses are so and so and so and so, and in my judgment and in my jurisdiction, in my court, they have been determined to be upright. وحلفت المدعي وحكمت له بالمال, and therefore I rule that the plaintiff, the defendant, is supposed to give this money. وأشهدت بالكتاب فلانا وفلان, and then as a witness on this letter is so and so and so and so. Okay, so that's just a little how the format of how it's going to go. And when we think about the section of al-buyu'a and al-mu'amalat, if we think of the section of transactions, we will remember that each little transaction, there's a sigha, there's a formula of how the transaction is supposed to happen, the verbal transaction. And I said, I think many times, I think we did that in two units, that you could even take that and you can create templates for all of those transactions. So a lot of these things, there would be templates that the court would follow, and they would be considered acceptable. Before we get to the next section, let me just see if there's anything else I wanted to mention. One thing I didn't say, I forgot to translate. So, and the two witnesses are considered right. وحلفت المدعية وحكمت له بالمال وحلفت المدعي I the plaintiff I had them swear and confirm confirm their claim. I'm sorry. Just so everything is above board. Okay, and as I said, you can find in other books of Islamic law longer formulas, and this is not like a fard that it has to be this way exactly verbatim. There might be some differences, so don't get sort of out of sorts if you find in the Muslims in India do something and the Muslims of Indonesia do something, but then the Malikis in Morocco do something else, or Mauritania. That's fine, but it's all within the same spirit. That the judge has to be very methodological in how they write and how they talk, and they have to verify, people's names have to be identified. And in the modern world, we'll add like some kind of ID, like a driver's license number, a national ID number, a passport number, a birth certificate number, something to identify them so that there's no confusion. Because when you deal with Muslims that come from Muslim backgrounds, a lot of the names can overlap. There's a lot of Muhammads and Ahmeds and Mustafas in a man's name, things like that. So there could be some kind of confusion. So that, the ID number becomes a way of verifying that. You have to list the witnesses. Also, what's the point of a witness if they're not known? So on and so forth. So the idea is for us to be above board. And then the other judge will have to deal with that when he gets it. One second. And then those witnesses that I write have been upright, they also have to be verified in the other court, in the other jurisdiction, so that there is an agreement, so then the ruling can be carried out. If not, then we're going to enter into a dispute, and we'll have to enter into more litigation between the two. Okay, so that's the kind of the bit that I don't feel like I did justice to in the last clip. And now we can move in to the division of property, ahkam al-qisma, which is, we said, either you're going to be dividing an estate because there's inheritance, or distributing a wasiyah, a bequest, which comes before the distribution of the estate. So if somebody dies and there's a bequest and then there's inheritors, both are happening at the same time. You have to distribute the wasiyah first. Well, you have to distribute the debt, the wasiyah, and then the property to the inheritors. And we'll pick this up, inshallah, in the next and final clip for today's unit. So we enter now into the section, the subsection of dividing property. Usually there are two types of cases. Not always, but usually. The first is in the case of death. When somebody dies, we have a few things that we have to do first. And you can remember the Arabic acronym TADUM. The Ta, Dal, Waw, Mim. TADUM. It's a made up word. TADUM. The Ta means tajhiz al-mayyit. So the first thing that happens from the deceased's wealth is you take from the deceased's wealth that which is enough to have them washed, shrouded, and buried. And then the Dal is a dain, any debt. So any debt that is owed, you take from the person's estate, satisfy the debt. And then the Waw is the wasiyah. If there's a bequest, you take from the person's estate, and you give the money to who they gave the bequest to. And then finally, the Mim, the Mirath, then you distribute according to the inheritors. Now, because there's a lot of the word distribution happens a lot in what I just said, this is where this section of Islamic law comes in, that the court has an appointed like trustee type of person, and they're experts in this. We're going to get into that right now. How are they going to divide it? And the reason that's important is, well, one, it has to be fair and according to the Sunnah or the Sharia. And number two, sometimes there are assets that are complicated. It could be land, it could be a complicated property, it could be a structure on a property, it could be something that is not necessarily divisible equally at prima facie, so therefore how is it divided? There's a lot that goes into it. It's not simply, oh, I have $10,000 and I have to split it two ways. Oh, how do I do that? 10,000 divided by two, 5,000. It's not going to be, it's usually, unfortunately, not that simple. And that's why we have this section in the court, or this capacity in the court to deal with it. We already cited the ayah in Surah An-Nisa, but we also have the hadith in Bukhari and Muslim, narrated by Jabir ibn Abdullah radiyallahu anhuma, that كان رسول الله صلى الله عليه وسلم يقسم الغنائم بين أربابها, that the Prophet صلى الله عليه وسلم used to distribute the spoils of war, the ghanaim, which we took in the last unit, to the people who are obligated to take it. And so the Prophet ﷺ himself did this. And of course, he's the most just and the most wise, sallallahu alayhi wasallam. So this is the sunnah in that case. Now, another important thing to keep in mind, why is this important other than things have to be distributed and they have to be distributed the right way, is that if you don't distribute things the right way, it can get lost and it can get confiscated. So, usually in the modern world, if you don't have some kind of document, will, last will and testament type of document, especially if you're a Muslim minority in a non-Muslim country, dictating how you want your property to be divided, sometimes, oftentimes, many times, the state can come in and take some of the money because there's like a death tax or that kind of thing. So to prevent that from happening, the distributors in the traditional fiqh, they prevent stuff from getting lost. And in the modern world, this is also a reminder that you can't just take it for granted that everything's going to happen smoothly after you die. It has to be kind of dictated, which gets more into like wills and Muslim minorities, which is not our topic for today, just mentioning it. Now, one of the things that has to happen is there has to be agreement and satisfaction by those who are going to receive their parts. If there is like something like the spoils of war, oh, I wanted that horse, not this horse, there has to be some kind of contentment. But in the case of inheritance, because this is dictated by the Quran, usually people don't get happy with what they get in inheritance, or some people get super happy and some people don't get so happy. That doesn't necessarily count. Okay. Then he says, let me get the book open. Okay, someone who divides the property for the court must meet 7 conditions. Okay. A Muslim, so this is not something that can be done by non-Muslims. In the Muslim majority context, that's what that is. Because you're dealing with Muslim property. Mature, so this is not something that can be done by a child of sound mind. Obviously, it can be done by somebody who's not of sound mind. Free, so this is not something that can be done by a slave, because the slave will have limitations in that regard. Male, so this is not something that is other than males, because it becomes a heavy public burden, so we don't put that public burden on women. Upright, so all of the things we've been talking about, upright, it's the same thing is going to apply here. And then trained in arithmetic. So I did want to talk about that a little bit. Now, it's not just arithmetic, but it's also anything that is required to know that asset that is going to be divided. The distributor has to know, the trustee has to know that stuff. So in the traditional books of fiqh, they talk about land. So if you don't know anything about farmland, and if you don't know that this part of the land is worth 6 times more than this part of the land, you can't just divide the land this way and give one person this and one person this, and then the person that took this part almost gets nothing because it's useless, and the person that gets this much, is like increased in wealth tenfold. So you have to you would have to know that maybe you have to cut the land this way. So, or I'm just obviously I don't know farmland, so maybe that example is dumb, but you kind of get the theoretical idea. Is that you have to be able to know that which is being distributed. So if somebody owns shares in a company, or somebody owns cryptocurrency, or whatever the case may be, you have to be able, as the distributor, you have to be able to know how to do that about that. So it's not just arithmetic. Yes, you need to know basic arithmetic. You need to know how to add and subtract and divide. And by the way, I have seen people that work for, not in a Muslim context, that work for government in doing similar type of work and are horrible at math and grossly miscalculate, overcalculate, undercalculate. I've seen it they're very sloppy. So don't be surprised that something like this is written in the books of fiqh. You have to know that. And by the way, in Al-Azhar, mathematics was a core subject that Sharia students had to learn, because we have inheritance, and we have things like property distribution, we have business transactions, we have zakah. So mathematics is an auxiliary science that you have to know to study the Sharia. I mean, I'm not saying you have to know trigonometry and quantum physics, or quantum physics is not math, but not advanced math, but you have to know basic math. You have to know how to run the numbers and understand how to calculate a third of something, a sixth of something, a half of something, how to calculate the nisab of the zakah, and how to distribute what 2.5% of that is, what 10% of it, what 5% of it, what the different types of 1/5 of it is, 20%. Etc. So mathematics is a subject that you have to learn. So if you don't know math, you got to know your basic math. So that's what he means by arithmetic. It has to be the basic technical knowledge that is going to be involved in the distribution. Now, at a bare minimum, they have to be qualified to know math. Okay, that I will say. But if somebody comes and they have they're dealing with the distribution of cryptocurrency, okay, you don't have to be an expert. There's really no expert yet in that. So you can ask. The distributor can ask an expert if it's a super refined kind of specific thing. Not in the book, but also in the Hashiyah, is that the distributor also has to be able to hear and see, has to be able to be articulate, and has to have dabt, has to be accurate. So these are the same things that we found in the judge, for example, in the witnesses, and things like that. So there are a lot more conditions that are simply the ones that are mentioned in the book. So it has to be somebody who's trustworthy. And then he says, if two or more parties agree that a particular person performs the division for them, the above conditions are not required. So in this case, what matters is that the money or the estate or the property is distributed, divided and distributed. So if all parties agree that Fulan is going to be and we're happy with that, then khalas, we fulfilled. We don't have to. Fulan doesn't have to go through the test to make sure that he has all of these conditions, or she, because that would be one of those conditions. But if they're happy with somebody to do it, then that's fine. This is the court-appointed trustee that is going to do this work. And this brings us to the end of today's class. Wallahu ta'ala a'la wa a'lam wa salli lahum ala sayyidina wa maulana Muhammad wa ala alihi wa sahbihi wa sallam. Alhamdulillah, in today's class, we backtrack just a little bit to review the section on a son testifying for his father, a father testifying for his son. So we also made note that the relationship of a father and a son, and vice versa, either upward or downward in the tree of lineage, is something that permeates other aspects of Islamic law. So I made reference to that. Then we talked about the judge writing to another judge in another jurisdiction, and the letter, and then the witnesses, and we kind of spent quite a bit of time on that because it is significant, because mostly there will be that type of situation exists. Not all litigants are always going to be of the same jurisdiction, and then the courts have to speak to one another, so there's a protocol for that. And I also made mention that this is something that's universal. This is not something that's unique to Islamic law, but all kind of legal systems have this. And then we moved into this next subsection, which is the dividing of property. And we learned that dividing of property usually is of two kinds. Usually there's property that's divided due to death. So that's taking care of the person's debt distributing any bequests and dividing the inheritance, and then also distributing property if there's a dispute in a business transaction and there's money or property involved, that the court appoints a trustee to distribute that property. And then therefore the person who does that has certain conditions. We read those conditions, which are pretty typical that we've been reading for like the witnesses and the judge and whatnot. But one thing that is new is that he said arithmetic. And by arithmetic he means that he has to have the technical skills to be able to divide that specific type of property. So usually arithmetic and an idea of land and how land is to be divided and in an equitable way. And if it's something that's a very refined issue, and I gave the example of cryptocurrency, then the distributor agent or the court-appointed trustee can ask an expert if it's something that's kind of new, super nuanced. You don't have to be an expert in everything. And I also made reference that studying math is one of the auxiliary sciences of the Sharia, because much of the Sharia in zakah, in inheritance, in distribution, etc., has to do with math, and you have to have the basic math. And in Al-Azhar, it was and is a basic science and a basic skill that you have to learn. I mean, just basic arithmetic and anything that might be needed for higher forms. Those are the major topics that we talked about. Walhamdulillahi Rabbil Alameen. Wa sallallahu ala Sayyidina wa Mawlana Muhammad wa ala alihi wa sahbihi wa sallam.